Good afternoon, fellow Rotarians. Is my microphone working? Yay! Ladies and gentlemen, today is my swan song. I'm having to leave town on Friday for a month-long vacation. I looked up the origin of the term swan song. It's from Greek mythology. It seems that the Greeks believed that just before a swan dies, he sings his most beautiful song. So that fortunately has come up to dies or retires. So this is my retirement podium stand or whatever. Now, we have a little different song today for you. And if my fellow singers will join me, Lori. Reverend Philpott, Lori, Vidal. Hey, Lori. Now, some of you may know this song if you're old enough, and I found that certain people, like my co-sergeant, never heard the song. It is Heart of My Heart. So we're going to run through it one time for you guys, and then you'll join in the second time. Here we go. Heart of my heart, I love that melody. Heart of my heart, brings back a memory. When we were kids on the corner of the street, we were rough and ready guys, and oh, how we could harmonize. Heart of my heart, meant friends were dearer then. Too bad we had to part. I know a tear would glisten if once more I could listen to that gang that sang Heart of My Heart. Now everybody! Heart of my heart, I love that melody. Heart of my heart, brings back a memory. When we were kids on the corner of the street, we were rough and ready guys, and oh, how we could harmonize. Heart of my heart, meant friends were dearer then. Too bad we had to part. I know a tear would glisten if only I could listen to that gang which sang Heart of My Heart. Woo! Pretty bad. That was excellent.
Okay, well, anyway.
Pledge.
I used to think I was indecisive, but now I'm not so sure. Would you join me in pledging allegiance to our flag? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Lori.
Well, this is a big day. What an honor for us to have our state attorney, Brian Kramer, as our guest speaker today, who has the responsibility of enforcing the law of the state of Florida. And we are so in line in Rotarians with Brian's responsibility as our Rotary exists to fulfill what? A four-way test. And with that in mind, I feel it's appropriate for us to use as our invocation today the foundation of Rotary, the four-way test to proclaim our unity of spirit with the law of the state of Florida. The four-way test of the things we think, say, and do. Is it the truth? Is it fair to all concerned? Will it build goodwill and better friendships? Will it be beneficial to all concerned? Today, may this be our prayer for Brian and for our Rotary. Amen.
Guests and visiting Rotarians, please remain standing for introductions.
Hello, everyone. You may recognize my friend Judith Hurley. She's been with me to visit our club before and always enjoys it, so we hope one day we'll get her to join. Judith moved here not too long ago from Miami when she retired as an oncologist.
Hello, fellow Rotarians. I'm happy to introduce Linda Carley, who is a friend of Diane Robar, from the president from the Downtown Club. She is checking out the clubs in the community. So please help me welcome Linda.
Now we have an important announcement from my co-sergeant, Eric Atria.
I know, whoa, Brandon. I know we all know how modest Randy is. So I wanted to take this time to personally thank him for helping me this year be Sergeant at Arms. I think Randy has become a great friend of mine. He's a beautiful human being. He's always been very encouraging and supportive of everything that I do. And so thank you, Randy, for sharing this responsibility with me this year.
All right, I get another practice run up here. It's coming up soon. Good afternoon, everybody. How's everybody doing? All right, all right. We had a board meeting last night, and as a result, we inducted a new member. We have Ashley Bryant with Meridian Healthcare. I don't think she's here today, right? But so thanks for joining, and guests that are out there, we'd love to have you be part of our club. One of the things that I want to talk about, I think we all forget as members sometimes that folks that are in the club that have a red badge, that have recently come into the club, trying to get their bearings and trying to understand what to do in the club and things like that. If you have a moment, if you have an opportunity, seek out those red badges and make them feel welcome. And if you have a red badge, I would encourage you to just go sit at different tables, and you get to know some members in the club. So I would encourage you to do that. Also, membership. So over this year, we've lost some members. We usually have hovered around 200 members or so. And so I'm going to challenge the club to really think about inviting a guest that you think would enjoy Rotary. So if you can think about, somebody that you're a colleague or a friend or somebody that would enjoy, what we do, I think that would be a really good thing. And, we obviously want to, we have seasoned people in here, of course. And nothing wrong with that. In fact, I think seasoned people are very good. So even people that are just getting into retirement or looking for something to do, those are perfect individuals for our club. So think about that in addition to folks like Jamie, who recently joined our club, part of the younger generation. But, think about anybody that you think that might, thank you, Jamie, for being here. That's right. Representing. So anyways, that's what I've got to say related to that. And then the other thing is a big thank you for replying to the survey. We got about 89 responses, so that's about half the club. I feel that is success. And you guys gave a lot of good feedback, so we really, really appreciate all of that. And so with that, I think I'm going to introduce Eric. He's going to introduce today's program. Oh, one thing. No. Doctor, that certainly was a swan song. That was awesome.
All right, fellow Rotarians, I'm excited to introduce our guest today. He's a personal friend of mine. I've known Brian for about 16 years. We started trying cases together in the early 2010s. I was a very young upstart attorney, and he always treated me with the absolute utmost respect and fairness as a line prosecutor, and he rose the ranks and became the elected state attorney. I just want to say that a trial with Brian, I can almost relax because I know it's going to be so clean and so well done. And if we have a trial together, we rarely object because we're both so tuned in. And that doesn't mean we're not adversaries because we still fight hard. But I have the utmost respect for our speaker today, our state attorney, Brian Kramer.
All right, well, good afternoon, everybody. I appreciate you guys inviting me to be here. I am Brian Kramer. I'm your state attorney. I'll give you just a few minutes about me. For those of you who don't know me well, I am a true ACR. If you know what that is, then you, like they say, if you know, you know. But yes, I went to Terwilliger, Fort Clark, Buchholz, Santa Fe Community College, when it was a community college, and then went to law school at Stetson University College of Law in Gulfport, Florida. And I graduated there in 1993 and began my legal career past the bar in 1993. So I'm almost 33 years into the Florida bar. And began my legal career as an assistant public defender, did that for a while, and then switched over to being an assistant state attorney, a prosecutor, which by all accounts, I think most people have agreed I'm better at than being an assistant public defender. And certainly Stacey Scott would tell you that. And then I've been a prosecutor for about 29 years of the time that I've been a lawyer. I've done a couple of stints in private practice at various times in my life and always migrated back to the state attorney's office. And I want to introduce to you my executive director, Rebecca Schinholzer. She's been here with me before. And I held the position that Rebecca holds, which I'm going to explain in just a moment, for 9 years before I became the state attorney, and then was the co-executive director with my chief assistant state attorney for a couple more years before Rebecca became the state attorney, the executive director. And so that's kind of me in a nutshell. I have 2 adult children, Cassidy, who is in dental school at Columbia University in New York City in her 4th year, and Haley, who is a medical student at the University of South Florida in Tampa, and she's wants to be a radiologist. And I'm married to Annette, my wife of 30 plus years. Don't tell her I couldn't remember. Now, to be fair, she never remembers what our anniversary date is. She knows it's in late December, but she can never pick the date. So that's a little bit about me. Eric said I have 10 minutes and then 5 minutes for questions. Well, 20? Oh, this is a luxury. Okay. And so I wanted to give you a little bit of a craft talk and what is the state attorney's office. And I'll start by saying this. When we're doing our job well, you shouldn't hear about us, right? No one generally hears about the state attorney's office until something goes very poorly. And so I take pride in the fact that no one really knows that we're around or what we do, because we generally do our job very, very well, and we do it in a way that really doesn't garner a great deal of attention. So the state attorney is in Florida. In Florida, there are 20 judicial circuits. There are 6 district courts of appeal, or 6 districts, 20 judicial circuits, 67 counties, right? So most judicial circuits are more than one county. We have several that are single county. So Miami-Dade is a single county. That's the largest one of our judicial circuits. But then you also have right next to them, the Keys is a single county, and it's the smallest of our judicial circuits. They only have 90,000 residents. We are in the 8th judicial circuit, which is Alachua, Union, Baker, Bradford, Levy, and Gilchrist County. So I'm the state attorney for all of those counties. That's about 4,300 square miles and about 450,000 constituents. And I have a lawyer, or at least one lawyer, who works in every one of those counties. We have an office in each one of those counties. At least one lawyer in Alachua County, for instance, we have approximately 30 lawyers who work here in Alachua County. Gilchrist County and Union County, we have one or one and a part-time lawyer who work in those counties, and it's all based upon caseload and things like that. But what we do, I think most of you probably know, is that we prosecute criminal offenses. I ran some numbers just to give you some ideas of what this looks like. So in 2025, we assisted approximately 5,700 individual victims in the year 2025. So that's people who had criminal cases in which they were the victim. In an average year, we average about 19,000 individual submissions to the office. So those could be as simple as a driving while license suspended charge, or it could be as complicated as a death penalty case. So it runs the gamut, but we have about 19,000 a year. And so I became the state attorney in 2021, and so I had my IT director tell me, how many cases have we handled since I've become the state attorney? And it's 100,500 cases since I've been the state attorney. And I would say there's a solid 10 or 12 of those that didn't go well, so I'm going to give myself an A+. So, just to give you an idea kind of the volume of cases that we deal with. So we also do, or I also do some things, because I handle them mostly myself, that you would not expect the state attorney's office to do. So this, under the Constitution of the state of Florida, the state attorney represents the state of Florida in the circuit court. And so there, as I said, there are 20 judicial circuits, we're in the 8th. The Attorney General represents the state of Florida in the district courts and before the Supreme Court. So that's kind of the difference between the Attorney General and the state attorney as to what courts we're actually working in. And so, for instance, if any of you guys are in construction or building, if you've ever been involved in a project where someone is going to bond off the infrastructure to build like a large neighborhood, a Hale type neighborhood, there's something called a bond validation measure. And in a bond validation measure, you're basically saying, we need to prove to the people who are going to issue the bond that the bond is going to be repaid. So in order to do that, they have to sue the state attorney. And so they sue me, and I have to agree or disagree that the bond is valid, and then there's a court order that comes out. It's very esoteric part of my job, and not one you would expect us to have to do, but there are these small, strange, esoteric things because we represent the state of Florida in the circuit court that we end up doing. Just to kind of explain the structure of the office to you, to give you some understanding of it. So if this were a corporation, I would be the president of the corporation. Underneath me, I have Rebecca, who is sitting right here, and she's the CEO. So she's the chief executive officer of the corporation. And sitting next to her would be Heather Jones, who is the chief of operations, or the COO of the office. So Heather is my chief assistant state attorney. Rebecca is also an assistant state attorney. She was for many years, 20-ish years, the division chief for our juvenile division. And so Heather's job is to decide, how is this situation going to run? What are we going to do? What are the processes? How are we going to intake cases? Where are people going to be assigned? Who's going to get what kind of cases? Those type of things. Rebecca's job is to make sure that everything that Heather needs to execute is funded and staffed properly. So under Heather, she has, I think we counted the other day, 10 division chiefs. So she has, there's one for every single county, then we have one for felony division, one for our crimes against women and children, and one for juvenile, and one for county court. So she has division chiefs, and then underneath the division chiefs, we have assistant state attorneys, and the assistant state attorneys and the division chiefs are the ones who are going to court, filing the charging documents, trying the cases. You know, they're there to working day to day. That's what they do in the courtroom. Then on Rebecca's side, she sits atop a board of directors. So she has 6 directors, I'm going to say, 5. Well, it depends if we count investigations. So she has IT, she has finance, she has attorney support, she has electronic data processing and document imaging, investigations, and what am I missing? Well, if I think of it, she'll let me know. So I'm probably missing an entire side of the office. But that, and then through that board of directors, she carries out the orders that are necessary to run the operations of the office based upon how Heather has designed and implemented the office. And my job is to talk to you guys to make sure that I agree with everything that they're doing. And I personally handle all the death penalty cases in the office. So it's just my personal feeling is that if I'm going to ask the citizens of the community to agree that somebody should pay that price for what they've done, I need to personally ask that of them myself. So fortunately, we're very fortunate. We don't have a great number of death penalty cases, but most of them come out of the prison system. So for instance, in Union County, probably 35% of the docket in Union County are all criminal cases that are coming out of the prisons. Probably around 25% in Bradford County are cases that are coming out of the prisons. In Union County, I'm fairly certain that there are more prisoners than there are citizens who live in Union County. So they have their own whole sort of internal justice system that, works there. But when the cases get to the point, and we work with them on like what cases are going to stay within their internal justice system and what cases are going to move over to the criminal justice system. But once they move over to the criminal justice system, then it becomes our responsibility to prosecute those cases to their conclusion. So, and unfortunately, we do have the occasional non-prison related death penalty cases, but a lot of the cases that we have that are death penalty cases are people who are already serving life in prison who have murdered people in prison. So that tends to be where the majority of them come from. So those are the cases that I generally stay personally involved in, but one of the role that I think I enjoy the most and the role that I think is one of the most important things for me to do is that I'm one of the most senior prosecutors in the office. Like I said, I have 29 years of prosecutorial experience. And so I meet daily, regularly with the different prosecutors in my office. We go over the cases, we talk about what is best. I tend to not be, I'm going to tell you what to do. I'm more of a, well, have you thought of this? And what if you tried that? Type of person. I try not to put my finger on what they're doing, give them the opportunity to reach the appropriate conclusion that they have. And then the other role I serve in is sort of I set policy and I set, try to be the role model for how we're going to interact. And I'm very thankful for Eric's words because, it tells me that I'm getting to where I want to be. We enjoy in the 8th Judicial Circuit, I think, one of the best relationships with the defense bar anywhere in the state of Florida. Certainly anywhere south of Miami. South of Orlando. I would say that our relationships are certainly better than what happens down there. And so what Eric was describing to you is what I try to push out to my lawyers, is to say to them, we enjoy, as prosecutors, we enjoy the greatest privilege that is known to the practice of law, which is we are not beholden to a particular client. We're beholden to the entire population of the state of Florida or to the constituents of our area. And so we have the privilege of simply acting appropriately, of acting with truthfulness, with being very straightforward in what we want and what we think is appropriate, to exercise judgment and exercise good discretion when that's appropriate to do so. And the fact that, I don't know if you guys have seen me, I come here sometimes with Stacy. Stacy Scott and I are personal friends. We've been personal friends for over 20 years. And we both work to push that congenial relationship out to our lawyers so that, because ultimately that's what serves the public the best, is to resolve the cases that need to be resolved and in a fair way that's fair and impartial to everyone, and then to prosecute to their conclusion through a trial the cases that need to be prosecuted in that way. Sometimes those are because we have a defendant who isn't willing to enter a plea. Sometimes that's because there are cases where the community just needs to decide. And so one of the things, the way I push that out to my prosecutors is that we never celebrate a victory in a trial or a loss in a trial. We celebrate the effort that the lawyer made. Win or lose, what I ask of them is be professional, be prepared, do your best, be fair to everyone, treat all people with respect. It doesn't matter who they are, it doesn't matter where they've come from. You're not always going to be able to relate to what somebody that you're dealing with has gone through. So I ask them to treat everyone with a great deal of respect. I ask people to exercise the 3 Ps, be pleasant, be polite, and be professional at all times. And because of that, I think we have a very, very high success rate. One of the metrics of success that I'm most proud of is the fact that we have on average, the lowest rate of turnover for any state attorney's office in the state of Florida, which means we retain our lawyers at the highest rate. And that is, you have to understand that statistic in the light of this. If you look at how much we pay compared to other state attorneys' offices in the state, we're generally the third lowest. So I take that as a point of pride that we have a very family atmosphere. We have an atmosphere where we celebrate individuals and we celebrate not their success, but their effort. And that, I think, has really helped us to maintain long-term relationships with many of our employees. I had one employee who retired, a year ago at 52 years. Now, I was only 56 years old at the time she retired, so I can't take all the credit, but what I can tell you is that it's an institutional, it's institutional, the way that we treat people and the way that we treat each other in our office, and she was a strong indicator of that. We currently have an employee who's almost at 40 years. So I'm very, very proud of that. I'm very proud of the work that we do, and I really take pride in the fact that we rarely end up on the front page of the paper. Most of the time when you hear about a criminal case happening, someone's sentenced or whatever, you don't ever see our name because we do the work quietly and we do it professionally, and that's the way I like it to be done. So I think that's probably 10 minutes. So I'll take questions, and you can feel free to fire off the difficult ones as well. Yes, sir. Mr. Mount. Or Mr. Atri.
I just think one thing that you could add that would be helpful is what's prosecutorial discretion in a filing decision. I think that's, most people would never know or see those decisions.
Sure. So what Eric's asked me is, what does it mean to have prosecutorial discretion? So under the law of the state of Florida, the state attorney does not have the legal ability to refuse to enforce a crime categorically. Like, I can't simply say, I'm not going to enforce DUI anymore. I have to. But what I can do is on any individual case, based upon the facts of that case, I can choose to file it if it meets the minimum requirements for filing, or not file it. And I can choose any reason or no reason not to file a criminal case, because the law and the Constitution of the state of Florida vest that discretion in the prosecutor. And there are minimum requirements to file a criminal case. You can't file a criminal case against someone that you know isn't guilty, or you know there isn't probable cause to believe that they committed the offense. But assuming you meet the minimum requirements, you can file it, but we never have to file it.
Brian, you may recall, or I'm not sure if you know, but in 1972, I was brought into Reuben Askew's office after Furman versus Georgia. We had been working in the legislature on revising the criminal code, and we thought we had an answer to Furman by ensuring that juries, or not juries, but judges, weighed a list of aggravating and mitigating circumstances in death cases. And the whole essence of that was an open process, a written opinion by the judge, where a reviewing court could tell with some certainty what factors mattered most, and try to remove this jury discretion, which behind closed doors that we had previously, which resulted in the death penalty being outlawed. It was upheld against Chevin's statute, which was a mandatory death statute that we thought was regressive and of an antique mold, as Justice Blackmun said. But in the intervening years, we've had two cases, Hurst and Ring, I believe, which said no, the right to the jury trial prevails, and if you're going to consider the death penalty, the jury has to make that decision. And I wonder, how has that changed the process? Do you think it's changed for the better or for the worse?
Well, that's a tough call. I was aware of the work you did with Governor Askew's office. I guess I would answer it this way. I hope that we have gotten to a point in society where we can have greater trust in juries to do what is right and what is fair. It's very clear from the direction of the Supreme Court case law that the right to for a jury to decide what the facts are underlying what you're going to be punished for is very strong. That wasn't always the case. 10, 15 years ago, judges were deciding all of this, like Mr. Mount said, and the arc has been towards juries deciding everything. There's been some recent cases where we're now having to have juries decide what date were you released from prison. So if we're seeking an enhancement, it's no longer the judge who gets to decide what date were you released from prison. You have to have a jury decide that because it's a fact upon which you might be punished. I hope the answer is that we're going in the right direction and entrusting juries with that responsibility. As the state attorney, my answer always is, I do what the courts tell me to do, and we abide by the laws the legislature and the courts set out. So I hope we're doing well.
Yeah, Brian, thank you very much. My friend over here didn't know what ACR is. Neither did I.
Alachua County resident.
Okay, so now I know. So that's and I've been an Alachua County resident for 26 years. I have a second question. I worked with guardian ad litem for 15 years, and as a result, many people, statistically, that age out of foster care go to prison. And as a result, I now advocate for prisoners. And so I have two questions. I'd like your point of view on number one, bail, and number two, the sentence for prisoners, because my understanding is that the prison system is the third largest employer in the state behind tourism and culture. And we have a large prison system with a lot of people in there for a lot of years. So the term limits for prisoners and your point of view on bail.
Absolutely. So we've had some reforms in bail over the last couple of years. I don't know whether you would consider them good or bad. Eric probably can speak for them as well because he's experienced a lot of them. One of the things that has happened recently in bail reform is the idea that we should not let people who have a lot of money out simply because they have a lot of money, and people who don't have a lot of money have to stay in because they don't have much money. That's a great idea. I agree with that. I think anybody who can and should be out pending trial. Anybody who is too dangerous to be out pending trial should be in pending trial. Unfortunately, the way that has manifested through the Florida legislature is that they passed a new set of rules and laws that are related to something that we call pretrial detention. And they're very onerous, I would say, on criminal defendants, that if you meet certain criteria, you're never going to get an opportunity for bail, that you're now going to be held without bail regardless of whether you could have made bail before or not. But they apply equally to no matter who you are. It's based upon what's your record and what crime are you accused of committing and what is the level of proof that supports that crime. On the other side, where there has been improvement, is that if you're not going to be held in pretrial detention, then the court is required to set a bond that you can make. So now the court is required to look at what can you actually afford to post, assuming we can't just release you on your own recognizance or you're on recognizance with conditions into the community. Obviously, if we can, we would. That's the first choice. Then if we can't, the judge is now required to set a bond that you have the financial ability to make. So that's an improvement, but overall, I mean, I don't know if Eric's shaking his head at me. It's not been an improvement because what I think has turned out is a lot more people are being held pre-trial than there were when people could make bond. It really has simply increased the number of people who can't get out of jail pending trial. So it's a bit of a mixed bag. Again, our job, my personal feeling is if you're safe to be in the community, I think that's fine for you to be in the community. But our job isn't to exercise my personal belief, it's to exercise the rules. And I'll be honest with you, for a while, we were not paying much attention to their new rules because things worked well here. And then there was a case where it was appealed to the District Court of Appeal, and the District Court of Appeal basically sent it back to us and said, what are you guys doing? You're not paying attention to the pretrial detention statute. And since then, we've had to pay attention. And I think it's resulted in more people being held in custody. On the prisoner side, I think you're right. I think Florida detains more people per capita than most other states do. You know, and that's a complicated problem. It's a complicated issue. And if it were going to be addressed, it would have to be addressed systemically through the statute. So, and I'll give you an example of something that I always find to be problematic. So if we were to say, if somebody were to commit a first-degree murder, and they're convicted, that's a mandatory life sentence, right? Well, if somebody were to break into a house and steal a gun, that could also get you a life sentence in Florida. So those are two very disparate crimes in the seriousness of the crime, but they can both be punished in very, very severely. And so what tends to happen is that the upper limit of punishment is high for a lot of crimes, and so it kind of depends on who's your judge and what county are you in and what circuit are you in, and can result in the option for a lot of incarceration. So if we were going to address it like you're saying, it would have to be something that I think would be very politically unpopular with our Florida legislature, which is they would need to downgrade a lot of crimes to limit the amount of incarceration that could be assigned to those crimes, or somehow limit the amount of time a judge can impose for a crime. So it would have to be a very systemic operation, and it tends to be very politically unpopular to do so. And I think what we know about all politicians is that they don't enjoy doing things that are going to be used against them when they want to be continuing on as a politician. Because when you do things that are politically unpopular, you tend to not be a politician anymore.
Don, if I can get this in real quick, Don. Jenny, about 15 minutes ago while you were talking, Brian asked about what you considered a case not going well. Sorry.
Well, what do I consider a case not going well? Well, for as many ways as things can fall apart and break apart, they do in the state attorney's office. So we can have witnesses who move away, disappear, stop coming to court, break off communication with us. We have had, more than I would like to say, law enforcement officers who get in trouble and their testimony becomes unavailable. We have had circumstances where we believe that we have a certain level of proof and we send stuff off to the laboratory, test it. Turns out we don't have that level of proof. There are many ways to crash and burn. It's nearly limitless in that we can have judges who set trials on days when witnesses aren't available. That's very problematic. There's all kinds of stuff that can go wrong. It's not trial is not a sport for the faint of heart. It is a dynamic environment where you have to be able to think on your feet and really spend a lot of time making lemonades out of lemons, and it can be very tough sometimes. But we hope that that's the exception, not the rule. Obviously, we try to. This is why we celebrate the effort, because the effort is preparation. And preparation is what leads to not having these bad outcomes. And that's the irony of it. Almost all my lawyers, they love to be in trial. They love being in the courtroom. They love the trial. They hate the preparation. Right? The preparation takes a long time. It's tedious. It's arduous. Things go wrong. Sometimes there's a lot of writing involved, motion work, that type of thing. They don't love that. If they could be like, hey, have somebody else do that, and I'll just show up in the courtroom and try this case, they're lined up out the door to do that.
Thank you.
Good afternoon. I'm Lauren Elliott. Thanks so much for coming today. So and you've touched on this a couple of times. I used to be the PIO for the Marion County Sheriff's Office. So I wanted to ask you about how important that is for the relationship between your office and the office of the sheriff and the police chief, how important those relationships are. I saw it myself in Marion County. That's probably all I have to say. Because there was a lot of distrust between the state attorney's office and law enforcement for a long period of time in Marion County. So I'd like to hear your feedback on that.
Well, one thing you have to understand, and I don't know that everybody would really know this, you would, there is always a natural tension between the state attorney's office and all of law enforcement. And I'll give you one statistic that supports that. Of the cases that are submitted to us for prosecution, we will ultimately file about 70% of those cases, which means that 3 times out of 10 that a law enforcement officer sends us something saying, hey, we think this is supported by probable cause and prosecutable, 3 times out of 10 we're telling them no. And about 2.9 times out of 10 they're saying we're wrong. That's the tension between them. But I would tell you this, in this community, we work extremely well with our law enforcement partners. And part of that is because we work together so much. We provide levels of support to law enforcement that aren't really provided in a lot of other communities. We have something that's called a sworn complaint. In some communities, they don't even know what that is. So a sworn complaint is somebody on the street, an officer, investigated something, they either couldn't or didn't make an arrest, and they send it to us. We take it over, and we start working on it, and we investigate it, and then we issue a warrant, and we bring the case for prosecution. In some communities, the state attorney's office takes the position that if you didn't make an arrest, there's nothing for us to do, and we're not getting involved. Not a good relationship builder with your police force, right? So we don't do that. The other thing we do is that when there's any kind of major crime, we have units. We have firearms crime related unit, we have a crimes against women and children unit, and we of course have our general felony unit, and we work with them during the investigative phase of the case, which is unusual for a lot of state attorneys' offices. Most of the time they wait until the case is submitted for prosecution. We don't wait. We are a resource. We act as a resource to them all the time. We literally have an entire department that sits there waiting for a police officer to show up without an appointment so that we can start providing assistance. They will issue warrants, they'll issue subpoenas. We bring, if you've heard you have the right to remain silent, officers, people can refuse to talk to the police. They can't refuse to talk to us. We have subpoena power. You can say, I don't want to talk to the police. You can't say, I don't want to talk to the state attorney. So one of the things we do is they know, and we do it it's all the time, is we have recalcitrant witnesses, great, we'll get the state attorney to talk to you. And then we have investigators go out and serve them the day, like major crime occurs, it'll be, if it happened the night before, we'll be getting subpoenas out to have people come in that day. We'll serve them instanter. You will appear today in front of the state attorney and you'll start giving testimony. So it's harder for us to have these bad relationships when we need each other this much. And that's kind of how we have it. And we really have a very, very good relationship with all of our law enforcement partners.
Hi, I'm Rebecca Nagy. Thank you for a fascinating talk. You mentioned that your attorneys are paid on a lower scale than most in the state. So can you tell us about the source of the funds for the salaries and how those salaries are determined and why our guys and gals make less than others?
Thank you. This is my favorite topic. It just tends to bore everybody. So here's how it works. 95% of all the money that comes into my office, which is about 12 million, a little over 12 million per year, funds the 45 assistant state attorneys that I have. And that is from the general fund of the Florida legislature, that they are the ones who provide that to us. 5% comes from the counties, and that accounts for, well, not all of it, but let's say about 2% comes from the county. That is for physical plant, that's for computers, and for telephones. That's under what we call Article 5. So the legislature decides how many lawyers I have and they decide how much I can pay them, okay? Sometimes that money comes to me with discretion. Sometimes that money comes to me without discretion. And so it's really a matter of how much does the Florida legislature give me and how has that been distributed over time versus other circuits within the state. One of the things that I love Gainesville, I love North Central Florida, but I will tell you, we are not powerful in the legislature. Does anybody remember, because some of you got, like, maybe you'll remember, when was the last time we had the Speaker of the House or the President of the Senate? Anybody remember? John Mills, right. Years and years and years, long before my time. If you have the Speaker of the House or you have the President of the Senate in your judicial circuit, you're going to get paid, and your people are going to get paid. That's the nature of the politics. It just so happens that we don't have that, right? We just don't get that here. So we fall behind, and over time, you fall behind because this circuit has it, and this circuit has it, and this circuit has it, and then we don't have it. And you fall behind, and you fall further behind. And that's really what accounts for it. The other issue is this. We are the largest group of lawyers in the state of Florida. The prosecutors, and if you combine us with the public defenders, with the legislature really kind of sees us as one unit because we're the lawyer, along with the regional counsel, we're basically the lawyers who run the judicial system. So they kind of look at us as one unit. There's over, if you put us all together, there's over 5,000 of us. And that's a lot of people to pay. And the salaries have become non-competitive, is really what it comes down to. One of the things I really enjoy doing is I teach trial practice at the University of Florida Law School. So I get the opportunity to meet young lawyers who are coming out of law school. So you get to know them and you do a little mentorship with them. And of course, I'm biased, so I want them to go into public practice. I want them to come to the state attorney's office and learn a craft. And so I'll ask them, how much are you going to get paid from this company that you're going to go work for when you get out? Oh boy. More than a circuit court judge, right? They're getting, so it used to be that we were maybe at half of what they would get paid. We're now closer to a third of what they will get paid if they go to a private law firm. And it's just non-competitive. The people that we end up getting are the people who feel the passion to be doing the work that we do. They're making a choice, and they also have to be able to afford to make that choice. Not every student who has gone through law school and acquired hundreds of thousands of dollars in debt can even make that choice if they want to. And that's really how we get there, and there is no correction on the horizon. You won't, the starting salary at my office is $70,000. And that's what we pay. The legal starting salary is $50,000, okay? You got students who are coming out of law school making $225, $250, no problem. So that's just where we are.
Brian, thank you so much for being here today and sharing your story and obviously your passion. We thank you for serving the state of Florida on our circuit, Rebecca as well. And we're going to make a donation in your honor to the Rotary Foundation. So we appreciate you being here. We're going to take a quick photo.
And I'm happy to stick around if anybody has any questions I didn't get.
Perfect. So anybody got any additional questions? Let's see. Next week's program. Let's see, what does it say? There we go. Chad Carr, UF Department of Animal Sciences. I'm going to do a quote of the day. Justice will not be served until those who are unaffected are as outraged as those who are. That comes from Benjamin Franklin, if you can imagine that. So, the Reading Safari winner is 697. If you got that number, it's your lucky day, and we're going to end with a four-way test once again. Why not? Is it the truth? Is it fair to all concerned? Will it build goodwill and better friendships? Will it be beneficial to all concerned? We are adjourned. Thank you. Mm-hmm.